I'm the Executive Director of the Future of Children Project, which comes out of the Woodrow Wilson School here at Princeton and the Brookings Institution in Washington, D.C. At the core of our project are our journals, which I hope you've had a chance to take the Juvenile Justice volume and our policy briefs. And on top of that, we do a lot of outreach activities as well. And I wanted to just give you a little background on the future of children so you know what resource we've given you, and hopefully you can pass it on to your colleagues and whatnot. We put together 2 volumes a year, and they're on a variety of topics. They range from marriage and child well-being to childhood obesity to juvenile justice. I mean, they really run the gamut. We did one last year on children and electronic media, and that was a great conference because we got to see teen virtual life, or whatever it was called. So we do a lot of different topics. And believe it or not, each volume takes us about 1.5 years to put together. We bring in authors, we ask them to write review articles, which are very labor intensive to write. And really, they're acting as consultants, where they're going through the literature and they're pulling together all the literature in a given area and really weeding it out and sort of throwing out the bad stuff and really putting the good stuff in here. And then we have a wonderful managing editor who really edits our material in a way that makes it pretty accessible for most people, whether it's within a field or not. So we're very proud of our product, and as I said, I hope you pass it on to your colleagues, because what I like to think is when you pick up this volume of Juvenile Justice, you really are getting an overview of all the literature that's out there that's been sort of vetted as being good and profound. And this volume, we have 5 senior editors who come out of Brookings and Princeton, who usually serve as the issue editors on the volume, but sometimes we have a topic that's so compelling that we have to bring in a guest editor, and Larry Steinberg was our guest editor for this volume and helped put this really put this conference together. I got thanked, but really he did all the intellectual work that went behind it. And it's been a wonderful experience to have somebody come in and really bring the expertise that he did to this product. So that's my plug for the future of children. Our volume that's coming out next fall is on preventing child abuse and neglect. So I know there's a lot of people in this room who will be interested in that, and I hope that we will do a similar conference like this on that important topic. So in this volume, one of our authors was Elisabeth Scott, who wrote the article with Larry Steinberg on a developmental perspective of juvenile justice. And I'm not going to take away the punchline, but you've heard a lot today about how important it is to look at teens and not as children and not as adults in terms of determining their culpability and decision-making capacity. Interestingly, when we first started this volume, this chapter was supposed to come last in the volume. And when we brought our authors and editors together for a rough draft conference, it very quickly became apparent that this had to go first, because you can't talk about juvenile justice without looking at the fact that these are kids who are not in the same developmental framework as adults. And so this became the first chapter in the volume, and I think really informed all the papers that came afterwards, because it's so important. So without further ado, I'm going to introduce Elisabeth Scott. She is the Vice Dean and Professor of Law at Columbia University. As many of you know from her work, she specializes in juvenile justice and family law issues, and we're very pleased that she's here today.
Thank you, Elisabeth. I'm just delighted to be here, and I'm really glad that you're not waiting for lunch while I speak to you. So my talk this afternoon is on the role that knowledge about adolescent development should have in the regulation of juvenile crime, and it's based, as Elisabeth said, on the article that Larry and I wrote in the Future of Children volume, and in turn that article is based on the book that you've already heard about that has just come out from, and Beth can hold it up since I'm not there. But there also is a flyer out on the desk which will tell you 4 different ways that you can order the book should you so desire. And it doesn't even mention Amazon.com, so there are lots of possibilities. Well, in the book, we offer a framework for juvenile crime policy that we developed through our work together over about a 10-year period in the Research Network on Adolescent Development and Juvenile Justice that was sponsored by the MacArthur Foundation. Our thesis in the book is pretty simple. It's that scientific knowledge about adolescence and juvenile crime is critically important as a foundation for satisfactory juvenile justice policy, and that this premise translates into a legal regime that for the most part deals with young offenders as an intermediate legal category, not of persons, neither children nor adults. In short, what we're proposing is a developmental model of juvenile justice. The idea that developmental knowledge is relevant to the regulation of juvenile crime was largely ignored by lawmakers in the 1990s, when politicians, apparently with enthusiastic public support, transformed a system that viewed young lawbreakers as youngsters whose crimes were the product of immaturity into one that was ready to hold many youths to the same standard of accountability that is imposed on adults. Now, as Larry and Tom mentioned this morning, there's evidence that this tide is turning, although you really wouldn't know it when you hear prosecutors talking about prosecuting 8-year-olds as adults. But policymakers and the public seem to be having second thoughts about a regime in which age and immaturity are ignored in calculating criminal punishment. In many states, as Larry indicated, lawmakers have reconsidered and in some cases repealed punitive laws that were enacted just a few years ago, partly because juvenile crime rates have been relatively low, and partly because tough sanctions are costly to taxpayers, which is a pretty important concern these days. Further, in 2005, the Supreme Court in Roper against Simmons held that imposing the death penalty on offenders for crimes committed as juveniles violates the Eighth Amendment prohibition against cruel and unusual punishment. The court offered several bases for its conclusion, but the heart of Justice Kennedy's opinion was a proportionality analysis that drew on an article that Larry and I wrote in the American Psychologist in 2004. In the article, we argued that developmental knowledge supports the position that the criminal choices of young offenders, even 17-year-olds, are less blameworthy than those of adults. So this afternoon, I want to describe the developmental argument for mitigation that the court adopted and apply it more broadly to juvenile crime policy. I'll argue that juvenile justice policy grounded in developmental knowledge is superior to the contemporary approach, in part because, as Simmons recognized, it's more compatible with the criminal law's basic commitment to fairness. But the case for a justice regime that distinguishes juveniles from adults is not only grounded in fairness to young offenders, a consideration that may not carry the day in the political arena. It also rests on a pragmatic calculation of the interests of the rest of society. And finally, I want to suggest, as has been suggested this morning as well, that this is a good time to begin a new period of law reform in the area of juvenile justice. At the outset, I should set the stage by saying a bit more about the major reforms in youth crime policy that took place mostly in the 1990s. This trend, under which the regulation of juvenile crime became harsher in virtually every state, was based on an unexamined assumption that any difference between adults and adolescents was immaterial in devising legal responses to youth crime. In fact, some advocates for tough policy seem to view young offenders as more culpable and certainly as more dangerous than adult criminals. John DiIulio's famous description of super predators in the mid-1990s captures the image of teenage criminals as a major threat to society. Legislatures across the country rushed to enact laws lowering the age at which juveniles could be tried and punished as adults for a broad range of crimes. But the most dramatic changes have come in the form of legislative waiver or automatic transfer statutes under which many youths who are legal minors for most other purposes are categorically treated as adults when they are charged with crime. This has resulted in the wholesale transfer of juveniles into the adult criminal system, over 250,000 a year by most estimates. At the same time, juvenile court dispositions became more like prison sentences, often extending well into adulthood. Questions about whether juveniles should be subject to the same punishment as adults get a lot of attention in high-profile murder cases, such as the 8-year-old Arizona boy who's in the news this week. But the issue also arises in many more mundane cases involving drug sales and property crimes. These reforms were fueled by rising juvenile crime rates, particularly homicide rates in the late 1980s and early 90s. In part, the legal changes reflected a disillusionment with the traditional juvenile court. As youth crime rates rose, politicians ridiculed the juvenile system and pointed to high recidivism rates as evidence that rehabilitation was a failure. Proponents of more punitive policies for juveniles cast the available options as either adult punishment, the only means to effectively protect the public, or a slap on the wrist in juvenile court. Across the country, lawmakers opted for public protection by redefining adolescent offenders, or many of them, as adults. Supporters may present the reforms as a coherent policy response to a new generation of dangerous young criminals, but close inspection reveals that often the process had the hallmarks of a moral panic, in which politicians, the media, and the public reinforced each other in exaggerated perceptions about the seriousness of the threat and the urgent need to respond. Often the process was triggered by a high-profile crime that captured the public's attention. In Arkansas, for example, legislative reforms lowering the age of criminal adjudication for juveniles followed the Jonesboro school shootings, in which two boys aged 11 and 13 killed 4 schoolmates and a teacher. These punitive reforms offend proportionality, a core principle of the criminal law. As those of you who are lawyers may remember from your first-year criminal law course, proportionality holds that criminal punishment should be based not only on the harm caused, but also on the blameworthiness of the offender. Now, the scientific evidence does not support a justice system that treats young offenders as blameless children whose crimes are excused, but it does support a mitigation-based model that treats adolescents as a separate legal category of offenders who are less blameworthy and deserve less punishment than typical adult criminals. The distinction between excuse and mitigation seems straightforward, but it is often misunderstood. In the political arena, it is often assumed that unless young offenders are subject to adult punishment, they're off the hook, escaping all responsibility. Developmental research points to several dimensions of adolescence that distinguish young offenders from adults in ways that mitigate culpability. These include deficiencies in decision-making capacity, greater vulnerability to external pressure, and the relatively unformed nature of adolescent character. Each of these attributes of adolescence corresponds to a conventional source of mitigation in the criminal law, and together they offer strong evidence that young offenders are not as culpable as adults. So first, consider diminished capacity. Under standard criminal law doctrine, actors whose decision-making capacities are impaired by mental illness or retardation, for example, are deemed less blameworthy than typical offenders. If the impairment is severe, their crimes are excused. There's considerable evidence that children and adolescents are less capable decision makers than adults in ways that are relevant to their criminal choices. Although few would question this claim as applied to children, the picture is more complicated for offenders who are 15, 16, 17 years old. The capacities for reasoning and understanding improve significantly from late childhood into adolescence. And by mid-adolescence, most teens are close to adults in their ability to reason and process information, what you might call pure cognitive capacities, at least in the abstract. The reality, however, is that they are likely less capable than adults are in using these capacities to make real-world choices, partly because of lack of experience and partly because teens are less efficient at processing information than are adults. In life, and particularly on the street, the ability to quickly marshal information may be essential to optimal decision-making. Other aspects of psychological development also lag behind cognitive development and undermine adolescent decision-making competence. The research documents what most parents of adolescents already know. The decisions of teenagers are subject to psychosocial and emotional influences that contribute to immature judgment, which can lead teens to make bad choices. It's probably not surprising that I first became interested in these issues when my daughter Christy was about 14 years old. Now, at that time, an orthopedist suggested that if Christy's mild scoliosis got any worse, that she would need to wear a body brace. Now, Christy understood as well as any adult what the surgeon was telling us about her condition, the medical options, and the consequences of choosing or not choosing the recommended procedure. But her response basically was that she would rather live her life as a pretzel than wear a body brace. As Christy's response suggests, teens tend to lack what developmentalists call future orientation. That is, as compared to adults, adolescents are more likely to focus on the here and now and less likely to plan ahead or think about the long-term consequences of their choices or actions. And when they do, they're inclined to assign less weight to future consequences than to immediate risks and rewards. Over a period of years between mid-adolescence and early adulthood, individuals become more future-oriented. Substantial research evidence also supports the conventional wisdom that teens are more oriented toward peers and subject to peer influence than are adults. Several studies show that susceptibility to peer influence, especially in situations involving pressure to engage in antisocial behavior, increases between childhood and mid-adolescence, peaks at about age 14, and then declines slowly during the later adolescent years. Increased susceptibility to peer pressure in early adolescence may reflect changes in individuals' capacity for self-direction as parental influence declines, as well as changes in the intensity of pressure that teenagers exert on each other. But the upshot is that adolescents are more likely than either children or adults to change their decisions and alter their behavior in response to peer pressure. Teens appear to seek peer approval, particularly in group situations, and thus perhaps it's not surprising that young offenders are far more likely than adults to commit crimes in groups. For example, consider the case of Tim Kaine, a 14-year-old junior high school student who had never had any contact with the justice system until one Sunday afternoon in January 1992. When he was playing video games with a group of friends. A couple of older youths suggested that they break into a neighbor's house just for fun, and Tim agreed to go along. When they entered the house, the boys were surprised to find the elderly neighbor and her son at home, whereupon the two older boys killed them while Tim watched from under the dining room table. Interviewed years later, as he served a life sentence under Florida's draconian felony murder law, Tim explained that he went along because he didn't want to stay behind alone and he didn't want to be called a fraidy cat. It seems very plausible that Tim's decision to get involved in the break-in was more than anything else the conduct of a 14-year-old worried about peer approval. There's another psychosocial factor that contributes to immature judgment. Adolescents are both less likely to perceive risks and are less risk-averse than adults. Thus, it's not surprising, perhaps, that they enjoy engaging in activities like speeding, unsafe sex, excessive drinking, and committing crimes more than adults. The story is actually a bit more complicated. In the abstract, on pencil and paper tests, adolescents are capable of perceiving risks almost as well as adults. In the real world, however, risk preference and other dimensions of psychosocial immaturity interact to encourage risky choices. Thus, on the street, in the excitement of the moment, and surrounded by peers, teens may be less competent at assessing risk than adults would be. A compatible account of why adolescents take more risks than adults is that they may evaluate the risks and rewards of risky activity differently. Studies suggest that adolescents tend to discount risks. So in studies involving gambling games, teens tend to focus more on the potential gains relative to losses than do adults. What distinguishes adolescents from adults in this regard, then, is not the fact that they're less knowledgeable about risks, but rather that they attach different values to the rewards that risk-taking brings. Finally, adolescents and adults also differ with respect to their ability to control impulsive behavior and choices. In general, studies show gradual but steady increases in the capacity for self-direction and control through adolescence. Research also indicates that adolescents are subject to more rapid and extreme mood swings, both positive and negative, than are adults. The connection between moodiness and impulsivity is not clear, but it is likely that extreme levels of emotional arousal, either anger or elation, are associated with difficulties in self-control. The developmental research on peer influence, risk preference, impulsivity, and future orientation identifies factors that generally affect adolescent decision-making in ways that contribute to immature judgment and lead to risky behaviors. We cannot study directly the process by which youths decide to get engaged in criminal activity, but it seems very likely that the psychosocial and emotional influences that shape decision-making in other settings play a role in teens' decisions to get involved in crime. Of course, not every teenager gets involved in crime. That depends on a lot of factors, including social context. But these influences on decision-making are normative, as psychologists use that term. That is, typical of adolescence as a group and developmental in nature. As was mentioned this morning, research in the last few years indicates that some of these psychological factors likely have biological underpinnings. Recent studies of adolescent brain development show that important structural change takes place during this stage in the frontal lobes, and particularly in the prefrontal cortex. This region is central to the brain's executive functions, advanced thinking processes that are employed in planning ahead, regulating emotions, controlling impulses, and weighing the costs and benefits of decisions before acting. Thus, the immature judgment of teens, to some extent, is probably a function of hardwiring. That immaturity is mitigating of culpability as a form of diminished decision-making capacity is not controversial, at least in the abstract. What is not so obvious is that two other sources of mitigation in criminal law also apply to adolescents and reinforce the conclusion that young offenders are less blameworthy than their adult counterparts. The first source of mitigation involves situations in which a person offends in response to extreme external pressures. Think about the defenses of duress and provocation. The criminal law does not require exceptional forbearance or bravery. A defense or a reduced sentence may be available if an ordinary, i.e. reasonable, person might have responded to the unusual situation in the same way that the defendant did. Because of the coercive circumstances, the actor is deemed less blameworthy than other offenders. The research supports that ordinary adolescents are subject to peer pressure to a far greater extent than adults, including pressure to engage in criminal activity. As I've suggested, most juvenile crimes are committed in groups, while most adult criminals act alone. In some high-crime neighborhoods, peer pressure to commit crimes is so powerful that only exceptional kids escape. As Jeffrey Fagan and others have explained, in these settings, resisting this pressure can result in loss of status, ostracism, and vulnerability to physical assault. Circumstances that many of these teens face in these social contexts are similar to those involved in claims of duress, provocation, necessity, or domination by co-defendants, and are appropriately deemed mitigating of culpability. The case for mitigation on this ground seems all the more compelling because, unlike adults, teens as legal minors are not free to leave their homes, schools, and neighborhoods. When adolescents cross the line to legal adulthood, of course, the formal disabilities of youth are lifted. Young adults can avoid the pressure by removing themselves from social settings in which it is hard to avoid involvement in crime, and thus adults have no claim to this kind of situational mitigation. A third source of mitigation in criminal law is evidence that a criminal act was out of character. At sentencing, offenders can often introduce evidence of their general good character to demonstrate that the offense was an aberrant act and not the product of bad character. Here, mitigation applies to the crimes of young offenders as well, not because of their good character per se, but because their characters are unformed. Beginning with Erik Erikson, psychologists have explained that an important developmental task of adolescence is the formation of personal identity, a process that for most teens extends over several years until a coherent self emerges in late adolescence or early adulthood, or even later. During adolescence, identity is fluid. Values, plans, attitudes, and beliefs are likely to be tentative as teens struggle to figure out who they are. This process involves a lot of experimentation for many teens, which can mean involvement in the kind of risky activities that I've described, including involvement in crime. Self-report studies have found that 80 to 90% of teenage boys admit to committing crimes for which they could be incarcerated. But the typical teenage delinquent does not grow up to be an adult criminal. The statistics consistently show that 17-year-olds commit more crimes than any other age group. After that age, the crime rate declines steeply. Most adolescents literally grow out of their antisocial tendencies as individual identity becomes settled. How many adults look back on their risky adventures as teenagers with chagrin and amazement? Maybe some of us. Almost every time I teach my Children in the Legal System course, I hear confessions from upstanding law students about their delinquent exploits as adolescents. This is true, often with expressions of gratitude at their good fortune to have emerged relatively unscathed. The research supports that much juvenile crime stems from experimentation typical of this developmental stage rather than from moral deficiencies reflecting bad character, as we might assume with an impulsive adult whose adolescent traits lead him to get involved in crime. The values and preferences that motivate the adult criminal are not developmental but characterological, a part of personal identity. This cannot be said of the crimes of typical juvenile offenders, whose choices, while unfortunate, are shaped by developmental factors that are constitutive of adolescence. Like an adult who offers evidence of good character, most adolescent offenders lack a key component of culpability, the connection between the bad act and the offender's bad character. The court in Simmons recognized this, rejecting the notion that we can be confident that, quote, even a heinous crime by an adolescent is the product of an irretrievably depraved character, end quote. Well, the reality, of course, is that not all young offenders grow up to be persons of good character. Some grow up to be criminals. Psychologist Terry Moffat, in a major longitudinal study, has placed adolescent offenders in two rough categories. A large group of what she calls adolescence-limited offenders, typical delinquents whose involvement in crime begins and ends in adolescence, and a much smaller group of youths whom she labels life course persistent offenders. Many of these youths are in the early stages of criminal careers. Their antisocial conduct often begins in childhood and continues through adolescence and into adulthood. In adolescence, the criminal conduct of kids in these two groups can look pretty similar, but the underlying causes and prognosis are quite different. This raises an important issue. Even if adolescents generally are less mature than adults, why shouldn't immaturity be considered on an individualized basis as is typical of other mitigating conditions? Not all juvenile offenders are unformed youths, and some may not deserve lenient treatment on the basis of immaturity. So what's wrong with allowing immaturity of juveniles to be evaluated on a case-by-case basis? Well, without question, individual adolescents vary in the pace of psychological development and character formation. But the problem with individualized assessments of immaturity, is that we currently lack the diagnostic tools to evaluate psychosocial maturity and identity formation on an individualized basis so as to distinguish savvy young criminals from ordinary teenagers. Thus, the practice that some courts have adopted of using a psychopathy checklist, a variation of an instrument developed for adults, in an effort to identify adolescent psychopaths is fraught with the potential for error. For this reason, the American Psychiatric Association restricts the diagnosis of psychopathy to individuals age 18 and older. Evaluating antisocial traits in adolescence is just too uncertain. There's something else to worry about if maturity is litigated on a case-by-case basis. The research evidence suggests that racial and ethnic biases can influence attitudes about the punishment of young offenders. Thus, decision makers may be particularly inclined to discount immaturity in minority youths. The integrity of any individualized decision-making process is vulnerable to contamination from racist attitudes, or more likely, from unconscious racial stereotyping that operates even among those who may lack overt prejudice. The developmental evidence that I have described indicates that adolescent offenders, because of their developmental immaturity, differ from their adult counterparts in ways that mitigate culpability, and that fairness supports recognizing this difference through the categorical classification of young offenders. But although the scientific evidence is compelling, principle alone will not dictate juvenile crime policy. Ultimately, the most compelling argument for a separate and less punitive system for dealing with young criminals rests on pragmatic grounds. Policymakers are well advised to attend to two important lessons from the scientific research on adolescence and crime. First, the research by Moffitt and others shows that most delinquent youths, even those who commit serious crimes, are adolescence-limited offenders who are likely to mature out of their antisocial tendencies. These youths are not headed for careers in crime unless correctional interventions push them in that direction. Second, adolescence is viewed by developmentalists as a critical stage during which youths acquire competencies, skills, and experiences essential to their successful transition to adulthood. This process involves an interaction between the individual and the social context, which can either facilitate or undermine the accomplishment of developmental tasks. For young offenders, correctional facilities and programs become the social context. If the experience of youths in the justice system disrupts educational and social development severely, it may irreversibly undermine prospects for gainful employment, successful family formation, and engaged citizenship. The upshot is that lawmakers concerned about reducing the cost of youth crime should not lose sight of the impact of sanctions on the future life prospects of young offenders. effective sanctions that invest in juveniles' human capital and facilitate their transition to conventional adult roles is likely to promote the interests of society as well as those of young offenders, as long as public safety is not unduly compromised. Supporters of recent reforms argue that tough policies promote social welfare by protecting the public from youth crime, and at one level they are correct. Juveniles who are incarcerated are not out on the street committing crimes. But their calculus is distorted because it exaggerates the threat posed by many young juvenile offenders, and it discounts the potential costs of harsh punishment. First, as lawmakers have come to recognize, the concrete economic costs of incarcerating youth are substantial. Dollars spent on prisons are not available for other public purposes. Now, this concern is even more compelling today, of course, than it was when we wrote the book. Moreover, the long-term crime reduction benefits of harsh sanctions are uncertain at best. The research on the impact of adult incarceration on normative adolescent offenders suggests that imprisonment undermines social maturation and educational progress and likely contributes to recidivism. A regime that aims to promote desistance and to reduce the costs of juvenile crime should be cautious about excessive use of incarceration. The effectiveness of juvenile correctional programs has been the subject of debate for decades, and until relatively recently, the views of most researchers about the ability of such programs to have a positive influence on young offenders could be captured in two words: nothing works. But in the past decade or so, this picture has brightened considerably, with new programs that adhere to the lessons of developmental psychology, such as multisystemic therapy, which was mentioned this morning, and also more sophisticated methods of analysis that allow researchers to sort effective and ineffective interventions more accurately. A growing body of programmatic outcome research indicates that several well-designed programs, if executed properly, diminish recidivism and likely enhance the prospects that young offenders will become productive adults. This does not mean, in my view, that we should return to the traditional rehabilitative model of juvenile justice. Punishment is an appropriate purpose when society responds to juvenile crime. But both adult prisons and juvenile correctional programs can impose punishment, and the juvenile system is much better situated to invest in the human capital of young offenders and to facilitate their transition to conventional adult roles. Under the developmental model, most young criminals would be dealt with in the juvenile system. From a developmental perspective, punishing a 16-year-old car thief or a small-time drug dealer as an adult is likely to be short-sighted because these are typical adolescent crimes. But a justice policy that takes mitigation seriously is viable only to the extent that public protection is not unduly compromised. Some adolescent criminals cause a great deal of harm, and some, older violent recidivists, should be tried and punished as adults. This safety valve is essential to the stability of the juvenile justice system. A lesson from the collapse of the rehabilitative model is that a viable juvenile justice regime must pay serious attention to the public's concerns about safety. I think this is, I know that I'm a bit of an optimist on this issue, but I think this is a good time to reflect on juvenile crime policy. First, as I've suggested, in a time of financial crisis, lawmakers should be eager to reevaluate policies that that involve costly and often unnecessary incarceration. Second, juvenile crime rates continue to be relatively low, although, as Larry said this morning, they are creeping up. Beyond this, the alarm that fueled the punitive reforms has subsided, although it could flare up again. Even supporters of tough policies are having second thoughts. I thought it was interesting that John DiIulio expressed regret about his characterization of young offenders as super predators, and he acknowledged that his predictions about the threat of juvenile crime had not been realized. As we discussed this morning, recent research also suggests that the public may be less enthusiastic about punitive policies than politicians seem to believe. In another study that we did in our research group, is called a contingent valuation survey, we asked 1,500 Pennsylvania residents to whether they were willing to pay for incarceration or rehabilitation. And what we found was that those who were asked about rehabilitation were willing to pay more than those asked about additional incarceration of juveniles, although both were described as being equally effective. Now, our findings, we thought, should be very interesting to policymakers, particularly in light of facts that we didn't reveal to our participants, and that is that a year of juvenile incarceration actually costs 5 times as much as a year-long rehabilitation program. Our study and other recent survey evidence that was discussed this morning suggests that the public does care about safety, but it's quite open to rehabilitation programs as a way of reducing juvenile crime. The public demand for get tough policies may often be a transitory response to a high-profile crime. Our results suggest that the political risks that policymakers face in responding cautiously to public pressure in the wake of these incidents may not be as great as they might surmise. As I mentioned at the outset, there's also some evidence that legislatures are having second thoughts about the punitive laws that they've enacted in the past generation. In several states, these laws have been repealed or scaled back. For example, in 2005, Illinois repealed a statute mandating adult prosecution of 15-year-olds charged with selling drugs near schools and housing projects. Colorado in 2006 abolished life without parole for juveniles, and last year Connecticut raised the age of adult court jurisdiction from 16 to 18. Lawmakers seem to be ready today to approach juvenile justice policy more thoughtfully than they have in a generation. And if so, a large body of recent research that was not available 20 years ago offers insights about adolescence and about young offenders. Our hope is that this scientific knowledge can serve as a more stable framework for juvenile justice policy than we have had in many years, one that is less driven by reactions by politicians to changing juvenile crime rates. Thanks.
We have about 10 minutes for some questions and answers from Professor Scott, if you'd like to ask.
Everyone just agrees. This is great. Okay. There's someone up.
Hi. I understand you were mentioning about the lack of future orientation for some adolescents and juveniles and how they make their decisions and the moving process of information. But does that necessarily cover every juvenile offender? Because over the past couple of years, mostly on a volunteer basis, I've worked with some juvenile offenders, and it seems like they understood the future pretty well, and it seems like they could process information very well. I think a lot of their problems, especially once they get over the age of 11 or 12, is they don't really believe that there is a future for them. They see that there's a future for other people, but they don't believe that there's one in their life, and maybe it's a social economic context and the fact that they're growing up on the street. They're growing up in the middle of broken neighborhoods and a broken family, so there's really no reason for them to see anything different. But it seems as if they have some cognitive ability. They know right from wrong, but they choose the wrong because they just feel that that's that's their life purpose, and that they really have no viable choice. It's not that they're not aware that there are other choices, but they think that that's just the way it is for them, that that's what society means for them to, how for them to live. Because when you walk around in certain neighborhoods in New Jersey and other states, you see drug deals going on. You see, a woman here mentioned that, some of the kids today, maybe the way when I was a kid I walked around with a pack of gum or candy to share with somebody as a defense to make sure they wouldn't beat me up when I grew up in Jersey City. Kids walk around with knives and guns now to protect themselves the way I may have walked around with candy and gum. So it's a whole different type of mindset that's out there. And the other thing that I'm finding with juveniles is that they think it's a rite of passage to spend time in prison. They think that's...
To spend time, say that
it's
again.
a rite of passage. That, the way Catholics have their adolescents go through confirmation and you have bar mitzvahs. For a lot of juveniles, they don't have that upbringing. So for them, being arrested and going to prison is how they become men. So I'm just, I'm just kind of wondering from a developmental perspective. And, when I was getting my master's degree, I, enjoyed reading a lot of what Kohlberg and Murray Erickson and Piaget had to write. But I'm just wondering how that applies to youth today who are growing up in such broken families and broken neighborhoods.
Well, I think that you are completely correct that to understand kids' involvement in crime, we have to put the immature adolescent into a social context, and that the reason that not all teenagers engage in criminal activity is that the social context in which kids grow up is very different, and that greatly affects their responses. So that in high crime neighborhoods, engaging in criminal activity is the thing to do. It's probably the thing that kids who are sort of most tuned in to peer approval might well think is what they want to do. And so I certainly agree with that. As to your first point, I think what you're saying is that the problem of responding to juvenile crime is a larger problem than simply responding to juveniles as juveniles. It's a problem of responding to poverty, of responding to a lack of hope in some communities. This is only a piece of that of the solution. It is true, even accepting your point that many kids who get involved in crime are hopeless and don't see a future for themselves. It is still true that kids, at the moment of making the choice to get involved in criminal activity, many kids are not thinking about the consequences, the future consequences of that activity. So it's a combination, I would say. No, well, we have a chapter in the book about that focuses on proposals that we think come out of the developmental model. So I'm not going to answer your question. You're going to have to buy the book. And no, I'm just kidding. It's not a detailed blueprint, but our instinct is that the structure of the system, changing the structure of the system to some extent is important, and the changes that we recommend to some extent would limit the discretion of certainly of prosecutors and also of judges. So, for example, we argue for a sort of rough proportionality as even in juvenile court as a response to in sanctions, in dispositions, so that there would be a correspondence between the seriousness of the offense and the sanction, in contrast to the sort of broad discretion that juvenile court judges have today. We also would argue that age 15, 16 should be the minimum age of transfer, and that transfer to adult court, and that transfer should only be a possibility for a juvenile who has been previously convicted of a serious violent crime and is facing charges on a serious violent crime. And for that category, the traditional transfer criteria could be applied. But I think in general, I mean, I think it's fair to say that we to some extent would limit the kind of discretion that juvenile court judges have, although we, you know, our intuition is that many juvenile court judges do want to do the best thing that they can for the juveniles who are in their courts.
Good afternoon, Professor. I wondered, you know, what is I want to walk away from this from this conference with a sense of, you know, sort of a soundbite on what the status is, or with mens rea in juvenile courts. And I sort of get the feeling, after practicing law for X number of years, that after In re Galt, you know, the system thought to sort of overlay the juvenile with all the protections of the adult court, and also with all the burdens of state of mind, as you know, as adults are required to have a particular state of mind to commit offenses. And I heard Professor Steinberg say, maybe I've got it, you know, maybe I didn't hear correctly, but that it looks like there is research indicating that a juvenile does have, that the default setting is that a juvenile does have a requisite mens rea, and that it should be decided whether he does or doesn't on an individual basis rather than on a carte blanche. If you're a juvenile between ages of X and Y, you're incapable of forming a state of mind. So I wonder where all that is, and I'm thinking if it is the default setting that juveniles really can't form the adult state of mind that now buys them big time in institutions, I wonder, is there a movement somewhere that's in effect to sort of put an end to the fiction that juveniles really do have the requisite state of mind to commit big-time criminal offenses or little-time criminal offenses?
I think, I mean, it's actually, the question that you ask is a pretty complicated one. My view would be that if what you're talking about is simple mens rea, criminal intent, that juveniles have that most, like a 6-year-old who picks up a rock and plans to throw it through a window is doing it intentionally. And in terms of what the criminal law looks at to determine whether intent is established, you would say that 6-year-old has intent. The reason to treat juveniles more leniently and to have a separate system that responds to juveniles differently from adults has to do with somewhat more amorphous deficiencies in the way they make choices to commit crimes, differences that are developmental and that are not culpable. And it also has to do with a kind of pragmatic conclusion that we'll all be better off if we respond to crimes that are committed by juveniles in a way that's different from adults, in a way that pays attention to the fact that they're in adolescence, the fact that they're going through a developmental stage in which the way that the system responds may well affect their ability to become conventional adults. So it's not really about mens rea, I would say, but I'd love to talk to you more about it there.